from the speaker's standpoint, 8 minutes goes really fast. So I'm going to tell you my message right at the beginning, so I'm set up when I run out of time. We began with Gail reminding us that dissent is being suppressed in a lot of different ways. My message is that to make the right to dissent meaningful, sometimes you have to level the playing field. And I want to talk about that in the context of a specific example of Aboriginal women being denied the right to dissent against systemic denials of their rights to equality, life, liberty, and security of the person, denied the right to participate in the first official public inquiry intended to address an extreme manifestation of their inequality, the British Columbia Missing Women Commission of Inquiry, also known as the Opal Inquiry. I was counsel to the Native Women's Association of Canada at the inquiry. My co-counsel was an Aboriginal rights lawyer from Toronto named Catherine Hensel. NWAC, as the Native Women's Association is abbreviated and known, has over 30 years of experience working for the rights of Aboriginal women right across the country. And through its Sisters in Spirit initiative, had created a very substantial database concerning the systemic and chronic phenomenon of Aboriginal women going missing and being murdered in numbers vastly disproportionate to those in the general population. In 2010, the government of British Columbia established the Missing Women Commission of Inquiry to study the facts and state responses to murders and disappearances of women in BC, a disproportionate number of whom were Aboriginal. As the first official public inquiry of its kind into this issue of missing and murdered women, the Opal Inquiry presented an important opportunity to shed light on why so many Aboriginal women are missing and murdered. And the best way to have done this would have been through rigorous cross-examination of the police and Crown witnesses by counsel to NWAC and counsel to other NGOs who had an interest in bringing forward issues of systemic discrimination, including violence against Aboriginal women, and the institutional expertise to do so. In a public inquiry of this kind, cross-examination is the primary means through which documentary and viva voce evidence can be tested. And effective cross-examination does require the assistance of legal counsel. It was known from the beginning that this inquiry would run for months. On May 2nd, 2011, Commissioner Opal, recognizing his need for assistance, granted standing to some organizations which, like NWAC, have special expertise concerning the disappearances and murders of Aboriginal women. NWAC was granted full standing, and in his decision, Commissioner Opal said, and I quote, "It is critical for NWAC to participate in the hearing process." And in a subsequent decision in which he fleshed out his findings, his decisions on standing and recommendations for funding for legal counsel, he made decisions for on standing and funding to facilitate the participation of the organizations to the extent, each of them, to their interest. And he acknowledged that NWAC had a direct interest in the outcome of the hearing, and I quote, "a large role to play in ensuring that the voice of Aboriginal women would be represented in the inquiry process." He knew, and he told the government, that NWAC and other organizations simply wouldn't be able to participate effectively without funded legal counsel. However, the Attorney General, shortly after Commissioner Opal's decision and recommendations on funding, announced that it would not honor the Commission's recommendations for funding of counsel and other knowledgeable NGOs like the Sakari Carrier-Sakani Tribal Council. And the result being that that the government effectively overturned the decisions of the Commission on Standing and shut out voices like those of the NWAC women. And I want to make it very clear, NWAC did not boycott this particular proceeding. NWAC wanted to step up and fulfill its public responsibility to assist in this, what could have been a really important process. It was shut out. On September 7th, 2011, 12 experts issued a letter, sent it to the Attorney General, saying this decision to overturn the Commissioner's decisions on standing through denial of funding was unprecedented in Canada. And the experts said that they were shocked and concerned. Well, I suggest to you that we should all be shocked and concerned. The experts said that this decision damaged irreparably the credibility of the Commission and removed from the Commissioner the capacity to undertake the assignment that had been given to him. This is a very disturbing development, not only for this Commission's processes, which NWAC has stated publicly has lost all credibility, but it's a serious blow to the integrity of the Commission inquiry, the public inquiry process, which has had a very important place in Canadian democracy. And as Leo McGrady mentioned, for example, the inquiry into the murder of Dudley George, known as the Ipperwash inquiry, that inquiry had remarkable credibility and has continuing positive effects because of the integrity of the Commissioner and the inclusivity of the process. Bear in mind that the voices of Aboriginal women are rarely heard in either political or legal processes. The consequences of the exclusion of NWAC and the other Aboriginal organizations, by the way, there are no Aboriginal organizations who participated in this proceeding in the end. The Commission heard from no Aboriginal organizations, and yet represent publicly funded, or publicly funded, sorry, I rush. I must rush. I have only a minute. The government funded 25 stateside police and other governmental parties. And I don't say that they shouldn't be funded for a very formal adversarial process such as a public inquiry, but the exclusion of the NGOs created structural inequality in the process. There has been no cross-examination of these officials regarding systemic discrimination against Aboriginal women from the perspective of organizations and lawyers who actually have a mandate, a brief, and expertise to do that work. And so I think the experts were right when they spoke of the manifest unfairness of this process. May I remind you as well that Aboriginal women have a right, pursuant to the UN Declaration on the Rights of Indigenous People, and pursuant to the Convention on the Elimination of Discrimination Against Women, to participate. It is a right under international law that Indigenous people be permitted to participate in decision-making processes affecting their fundamental interests, including governmental decision-making. What should have happened when this inquiry process was so seriously interfered with at a political level, what should have happened was that the process should have been halted. And the Commission should have done what we have recently learned Murray Sinclair, the head of the Commission on Truth and Reconciliation, has done, and that is to bring suit to cure a serious deficiency in the process. That Commission has brought suit because of non-disclosure of documents by the federal government, because of the unfairness of that evidentiary situation. And so I must conclude by telling you that the NWAC has stated publicly that it considers the Opal inquiry a failure, and it has no confidence that its report, which is imminent, its release which is imminent, will offer effective solutions to ongoing discrimination against Aboriginal women, including systemic violence. It may, and we hope it does, offer some answers to some individual families, but there is no, the report and the process simply has no credibility with NWAC or other Aboriginal organizations in terms of its capacity to address systemic issues of violence against Aboriginal women. And I believe that the perspective of NWAC and those other organizations is entirely justified, and say shame on British Columbia, and encourage you to support and understand why it is that NWAC and its brother and sister Aboriginal organizations continue to call for a national inquiry into missing and murdered Aboriginal women, a better inquiry than this one has been.